Start. It is well established that it is within the managerial discretion of an employer to organize and arrange his business in the manner he considers best. So long as that is done bona fide, it is not competent of a tribunal to question its property. If a scheme for such reorganization results in surplus age of employees, no employer is expected to carry the burden of such economic dead weight, and retrenchment has to be accepted as inevitable, however unfortunate it is. The legislature realized this position and therefore provided by section 25F compensation of soften the blow of hardship resulting from an employee being thrown out of employment through no fault of his. It is not the function of the tribunal, therefore, to go into the question whether such a scheme is profitable or not and whether it should have been adopted by the employer. In the instant case, the tribunal examined the propriety of reorganization and held that the company had not proved to its satisfaction that it was profitable. In the present case, the Industrial Tribunal has answered the reference which pertained to the validity of the layoff by means of the award and has recorded a definite finding about the layoff being unjustified and illegal. The tribunal has analyzed the settlement only for consideration of the provisions and terms of layoff. Moreover, in the case of Perry and Company Limited, the workmen were retrenched. Whereas in the present case, despite the standing orders providing for retrenchment in circumstances where the layoff was extended, the layoff was being indefinitely extended without resorting to retrenchment. This judgment is distinguishable in view of the facts and circumstances of the present case. The learned counsel for the petitioner company has then referred to paragraph number 10 of the judgment of the Supreme Court in the case of Tata Engineering and Locomotive Company Limited, which is as follows. The conclusion reached by the tribunal that the settlement was not just and fair is again unsustainable. As earlier pointed out, the tribunal itself found that there was nothing wrong with the settlement in most of its aspects, and all that was necessary was to marginally increase the additional daily wage. We are clearly of the opinion that the approach adopted by the tribunal in dealing with the matter was erroneous. If the settlement had been arrived at by a vast majority of the concerned workers with their eyes open and was also accepted by them in its totality, it must be presumed to be just and fair and not liable to be ignored while deciding the difference merely because a small number of workers in this case were not parties to it or refused to accept it, or because the tribunal was of the opinion that the workers deserved marginally higher emoluments than they themselves thought they did. A settlement cannot be weighed in any golden scales, and the question whether it is just and fair has to be answered on the basis of principles different from those which come into play when an industrial dispute is under adjudication. Over.